Okay, I'm going to go through code. This one is a lot longer, so this may be quite a long video. This is 424 FCA 424-A, Compulsory Financial Disclosure. This is about disclosing the financial income, etc., that you make, so that the support order can be made based on that, all right, and everything that may go down. Except as provided herein, in all support proceedings in family court, there shall be compulsory disclosure by both parties of their respective financial states, provided, however, that this requirement shall not apply to a social services official who is a party to any support proceeding under this act. So it's not going to apply to a social services official who is a party in any support proceeding under this act. No showing of special circumstances shall be required before such disclosure is ordered, and such disclosure may not be waived by either party. Again, such disclosure may not be waived by either party or by the court. A sworn statement of net worth shall be filed with the clerk of the court on a date to be fixed by the court, no later than 10 days after the return date of the petition. I'm going to say that again, no later than 10 days after the return date of the petition. Okay, so a sworn statement of net worth shall be filed with the clerk of the court on a date to be fixed by the court, no later than 10 days after the return date of the petition. As used in this part, the term net worth shall mean the amount by which total assets, including income, exceed total liabilities, including fixed financial obligations. It shall include all income and assets of whatsoever kind and nature and wherever situated, and shall include a list of all assets transferred in any manner during the preceding 3 years or the length of the marriage, whichever is shorter. I'm just going to read that because it's a time frame. I'm going to repeat all time frames. So a list of all assets transferred in any manner during the preceding, that means the 3 years that just passed, okay, preceding 3 years or the length of the marriage, whichever is shorter, provided, however, that transfers in the routine course of business which resulted in an exchange of assets of substantially equivalent value need not be specifically disclosed where such assets are otherwise identified in the statement of net worth. All such sworn statements of net worth shall be accompanied by a current and representative paycheck stub and the most recently filed state and federal income tax returns, including a copy of the W-2's wage and tax statements submitted with the returns. In addition, both parties shall provide information relating to any and all group health plans available to them for the provisions of care or other medical benefits by insurance or otherwise for the benefit of the child or children for whom support is sought, including all such information as may be required to be included in a qualified medical child support order as defined in Section 609 of the Employee Retirement Income Security Act of 1974, 29 U.S.C. 1169, including but not limited to 1. The name and last known mailing address of each party and of each dependent to be covered by the order. Again, the name and last known mailing address of each party and of each dependent to be covered by the order. 2. The identification and a description of each group health plan available for the benefit or coverage. Hold on. Coverage. Oh, shit. Hold on. Coverage of the disclosing party and the child or children for whom support is sought. 3. A detailed description of the type of coverage available from each group health plan for the potential benefit of each such dependent. 4. The identification of the plan administrator for each such group health plan and the address of such administrator. 5. The indemnification numbers for each such group health plan. And 6, such other information as may be required by the court. That's a lot of detailed information. I don't know if all of that shit's going to be on the test. I just want to read the code. I don't want to miss anything. So let's just do this. Let's just suck it up and do it. Okay, B. Okay, so the next two, B is going to be about when the respondent fails to provide that information, that net worth statement. And then C is going to be when the petitioner fails. When the petitioner fails, it's just going to be an adjournment. No big whoop. But when the respondent fails, it's going to be a little more fucked up. So when a respondent fails without good cause to file a sworn statement of net worth, a current and representative paycheck stub, and the most recently filed state and federal income tax returns, including a copy of the W-2s, wage and tax statements submitted with the returns, or to provide information relating to all group health plans available for the provision of care or other medical benefits by insurance or otherwise for the benefit of the disclosing party and the child or children for whom support is sought as provided in subdivision A of this section, the court on its own motion or on application, the court on its own motion or on application shall grant the relief demanded in the petition, or shall order that for purposes of the support proceeding, the respondent shall be precluded. He's going to be left out because he didn't provide what he needed to provide. So now he's screwed. The respondent shall be precluded from offering evidence as to the respondent's financial ability to pay support. He had that time. What was the time frame on that he had? I don't remember off the top of my head, but now I got to go back because it's going to drive me crazy. Sorry. All right. He had how many days to file that shit? No later than 10 days after the return date of the petition. He didn't do it. He didn't file that network statement. So guess what? The court is precluding him from offering the evidence at this point because he didn't do it within the time frame, which was no later than 10 days. He's precluded from offering evidence as to the respondent's financial ability to pay support. Bam, he got screwed. He screwed himself. C, when a petitioner other than a social services official fails without good cause to file a sworn statement of net worth, a current and representative paycheck stub, and the most recently filed state and federal income tax returns, as provided in subdivision A of this section, the court may on its own motion, or upon application of any party, so the court on its own motion, or upon application of any party adjourn such proceeding until such time as the petitioner files with the court such statements and tax returns. The provision of this subdivision shall not apply to proceedings establishing temporary support or proceedings for the enforcement of a support order or support provision of a separation agreement or stipulation. Again, the provisions of this subdivision shall not apply to proceedings establishing. This isn't about temporary shit. This isn't about establishing temporary support or proceedings for the enforcement of a support order or support provision of a separation agreement or stipulation. Okay, and that is 424A, compulsory financial disclosure. Let me see if I can sum this up. Maybe I could do a short on it. So again, 424-A, compulsory financial disclosure. This is about, in all support proceedings in family court, there shall be a compulsory disclosure by both parties of their respective financial states. Okay, they're going to be asked to submit what's called a net worth statement. This is of all their financials, like W-2s and tax returns and all of this stuff. Okay, and that should be filed with the clerk of the court, okay, on a date to be fixed by the court, no later than 10 days after the return date of the petition. All right, so they have to do that. All right, and if the defendant fails to do that, the court is going to preclude the defendant from offering evidence because he didn't do it within no more than 10 days. He lost the ability to submit that net worth statement and his financial income and X, Y, and Z. So the court will preclude him if he fails to do so within the time limit provided from offering evidence as to the respondent's financial ability to pay support. And the court's just going to take it the way they have it since he didn't provide it. Now, if the petitioner doesn't, then they're just going to adjourn. And that's that.